session. So here's the historical context. So prior to the Mental Capacity Act, there was a patchwork of different pieces of legislation and practices and pieces of guidance surrounding individuals with impaired mental capacity. This often resulted in inconsistency, in some cases a lack of clarity, but also there was a potential for abuse. So the need for change was significant, and the idea was to put together a unified legal framework to essentially promote people's rights, autonomy and freedom, and a shift from protection to empowerment and support. So when we think about the Mental Capacity Act in terms of when it came into force, so it came into force the tail end of 2007 and was a sliding introduction into early 2008. So there's a code of practice. So professionals working with individuals who lack capacity have specific responsibilities under the Mental Capacity Act. And within the code of practice, it essentially takes the legislation itself and puts it into a practical sense and puts it in a way that you and I can read and practically apply. So there's 5 key principles under the Mental Capacity Act, and we're going to look at them individually. So the first is a presumption of capacity. Individuals must be presumed to have capacity unless it is proven otherwise. Second principle, supporting decision making. So people with impaired capacity should be supported to make their own decisions. Number 3, the right to make unwise decisions. Number 4, best interests. So when an individual does lack capacity, decisions must be made in that person's best interests. And number 5, the least restrictive option. We should look at the option which is least restrictive to that person's freedom of choice and freedom of actions. So let's have a look at each of these 5 principles individually. So the first is a presumption of capacity. So the MCA emphasises that individuals are presumed to have capacity unless it is proven otherwise. This means that everyone is treated as having the ability to make their own decisions unless there is clear evidence to the contrary. So this particular principle underscores the importance of personal autonomy and freedom of choice. You can imagine if I encounter an individual and start with a presumption of lack of capacity, that negative starting point is likely to then influence the whole way that I interact with that particular individual. So this first principle is important. I should always presume capacity. Now bear in mind the Mental Capacity Act is triggered at the age of 16. So essentially on somebody's 16th birthday, they are presumed in the eyes of the law to have capacity. Next, supporting decision making. So the MCA highlights the importance of supporting individuals with impaired capacity to make their own decisions. This involves in providing information, guidance and reasonable adjustments to help them understand their choices and to help that individual to make informed decisions. So this principle emphasises a person-centred approach, prioritising the individual's perspective and agency. So when we think about supporting decision making, what we're talking about is what can we do to present information in a way that a person is more likely to understand? How can we adjust and flex and maybe condense or simplify information, or maybe present it in a way that a person is more able to take on board, again to help and to assist that person in their process of making their own decisions. The third principle is the right to make unwise decisions. So the MCA acknowledges the right of individuals to make decisions that others might consider to be unwise or illogical. The Act emphasises respecting an individual's autonomy, even if their choices are not aligned with what can be considered conventional wisdom. This principle protects the right to self-determination and emphasises the importance of personal values. Now, when you think about it, we all make decisions every day. Now, obviously, some of those decisions are quite simple and some of those decisions are more complex. But some of those decisions, somebody else on the outside looking in may say, that decision is awfully unwise. But when we think about principle 3, the idea here is that, is it for me to say a decision is unwise? I mean, if I'm saying a decision that somebody else has made unwise, well then, that therefore suggests I'm wise. But then who nominated me? Me? So this idea that people have got the right to live their life in the way that they choose. It's not for me to say to another adult, well, this is what's necessarily right for you. Don't get me wrong. I can give advice. I can give guidance. But I've got to be very careful to maintain and respect that person's essentially freedom of choice. Number 4, best interests. So when an individual lacks capacity to make a decision, the MCA requires that any decision made on their behalf must be in their best interests. This involves careful consideration of their past wishes, beliefs and values, as well as their current circumstances and current well-being. So this principle underscores the ethical obligation of ensuring that the way that we work benefits and is centered around the individual. When we think about sort of person-centered working, it's kind of very much links into this idea of best interest. Now, when we think about best interest, the way it was first introduced to me was trying to ascertain or trying to figure out what the person would have likely chosen, were they able to choose, and then trying to get as close to that as possible. And quite often that particular description works really well. What I would say, however, is that in some cases, acting in somebody's best interest is actually protecting them from themselves. And there's a number of cases where that is exactly the case, that actually the steps that are being taken by professionals working with that individual or supporting that individual actually in some cases may have to restrict that person somewhat to actually act in their true best interests. Talking about restrictions, principle 5, the least restrictive option. So the MCA stipulates that when supporting an individual with impaired capacity, the least restrictive option must be chosen. This means that any actions or interventions should be as minimal as possible while still ensuring the health and safety and the well-being of the individual. So this particular principle prioritizes minimizing the impact of any interventions, but promoting people's freedom and independence. So what this essentially says is that if we're going to be putting or placing particular measures in place, if we're going to be putting something in place that's going to restrict that person, are there ways in which that restriction can be reduced or limited? Is there another way? And I think that's really the key with principle 5. It asks us, is there another way to achieve this particular goal, this particular outcome? Are there ways we can work with this individual that restricts this person less? Now, when it comes to assessing a person's capacity, if we look at the code of practice, it stipulates that anyone can assess capacity. Now, essentially, there would be certain individuals who may be better placed, but the way it focuses is in this particular way. So the idea here is the person who should be assessing a person's capacity is the person who's making a proposal to that particular individual. So they're proposing a choice to that particular individual, or the person who's undertaking the next stage in a particular process. So an example could be a person, a carer in a care setting, may propose that their resident has their toenails cut. So therefore they may propose that a chiropodist comes to address that person's toenails. That's the proposal. Now again, I've then got to assess the individual's capacity to consent to the chiropodist coming along. But then when the chiropodist arrives, they would also have to assess that person's capacity in order to ascertain, has this person changed their mind? Or maybe they didn't have capacity the first time round, but maybe now they do. Now, the process for assessing capacity changed in 2021. So this may be a slightly different sequence to what you've typically seen before, but there was a case that went to the Supreme Court in 2021 where they agreed that this is now the correct sequence. So the first stage is the functional test. Now, bear in mind when we assess capacity, it's time and decision specific. I'm not looking to ascertain whether somebody has capacity full stop. All I'm looking to ascertain is right here, right now, does this person have the capacity to make this specific decision at this particular time? So stage one is the functional test. Now, for a person to have the capacity to make a specific decision at a particular time, they have to be able to do these 4 things with regards to that decision. Number one, they have to understand the information which is relevant to the decision. So we can sort of think about this as, what is the core information with regards to that particular decision? And the person has to sufficiently understand that core information. Number two, the person has to retain that information. And they have to retain that information for long enough to use that information, weigh it up, maybe compare and contrast the options. Then the person has to be able to express a preference by talking, using sign language, or whatever other means that person has at their disposal. Now, it's said that if a person has the ability to do those 4 things with regards to that specific decision at that particular time, then that person would be considered to have capacity to make that decision, and they should go and they should make that decision. If, however, a person is unable to do if a person is unable to do all 4 of those things, then we move on to the diagnostic test. It's where I determine whether the person has an impairment of or a disturbance in the functioning of their mind or brain. Part of the second stage is then to establish whether the impairment of the mind or brain is what is causing the inability. So if a person is unable to do one of those 4 things, if the person has an impairment of the mind or brain, and that is what is causing that person to be unable to do those 4 things in the first part of the test, then that person would be considered to lack the capacity to make that specific decision at this particular time. Now, of course, capacity fluctuates, and of course, in some cases there may be certain times of the day. Now, ideally, if I can wait until a better time, then I should. But of course, in some cases, that's not always going to be an option, and I may have to assess that person's capacity as they present at that particular time. Documenting capacity assessments is incredibly important. So detailed records must be kept of any capacity assessments that have been conducted. This documentation should include the date of the assessment, the specific decision being considered, but also other factors that influence the decision, but also the specific outcome of the assessment. Now, these records, as you can imagine, serve as a vital reference point for future decision making, but also provide legal protection. Now, bear in mind that you are legally protected as long as you are acting in a person's best interests and as long as you are following the code of practice. And as you know, you may be familiar with the saying, if it isn't written down, then it didn't happen. And exactly that with capacity assessments. There should always be detailed documentation. Now, if the decision that person is facing is particularly risky, then of course that documentation needs to be more substantive. There needs to be more detail. There may also be the need, in some instances, to involve an IMCA, an independent mental capacity advocate. So IMCAs are an independent professional appointed to provide support and guidance to individuals with impaired capacity. They ensure that the person's rights and wishes are understood and that they're taken into account when decisions are made. They play a crucial role in promoting autonomy, but also safeguarding the best interests of the individual. Now, the key here is that the IMCA is acting as the voice of the individual. They're there to basically present and ensure that the person's wants, needs, desires, wishes are conveyed. Now, an IMCA must be engaged if a person is facing long-term or permanent change of accommodation. An IMCA must also be engaged if a person is facing a serious medical intervention, for example, surgery. An IMCA may be engaged in things like care reviews or safeguarding reviews, but as I say, it's the first 2 that I mentioned there where it's obligatory. Now, one element of the Mental Capacity Act, which was a real sort of move in the right direction, was lasting power of attorney. So lasting power of attorney essentially replaced, to a degree, enduring power of attorney. Now, where lasting power of attorney is better is that what it does, it allows individuals to appoint people, to appoint trusted people, to be able to make decisions on their behalf should they be unable to in future. And that's really what lasting power of attorney is. It's about me specifying who I want to make decisions for me should in the future I be unable to. Now they're broken into two different categories. First, it's health and welfare. So this allows someone to make decisions about personal care, health and welfare. The second is property and financial affairs. So again, this would enable somebody to be able to make decisions about my finances, property, investments and such forth. So this particular process is administered by the Office of the Public Guardian. So if you go onto the Office of the Public Guardian's website, it'll be able to provide you more information about lasting power of attorney. This is something you can apply for yourself, but the only snag is in order to basically apply for a lasting power of attorney and to appoint individuals, a person has to have capacity at the time. So they have to have capacity to be able to do this. So this is particularly important if you're an individual where you've been diagnosed with a condition where where your cognitive function is likely to decline. So for example, if a person is diagnosed with a form of dementia, for example, and you know that person's capacity is likely to decline, better sooner than later when it comes to a lasting power of attorney. And again, you can specify anyone that you wish. So it could be a relative, it could be a friend, a neighbour, that you believe would have your best interests, but also would be in a position to be able to speak up on your behalf. Now, in some cases, when it comes to the Mental Capacity Act and when it comes to making decisions in a person's best interest, in some cases there can be disagreements amongst professionals, or in some cases disagreements amongst professionals and family members, and that's where the Court of Protection comes in. So we have the Court of Protection, then above that we have the Court of Appeal, and then above that we have the Supreme Court. That's essentially the hierarchy. So the Court of Protection. So the Court of Protection safeguards individuals lacking mental capacity, making crucial decisions about their welfare, property and finances. Its jurisdiction balances individuals' rights with necessary protection and support. So the idea here is if there is a disagreement about what is in a person's best interest, and there's disagreements between professionals or between professionals and family members, the decision then goes to the court, and a judge will then make a decision on that particular case and will make a judgment. Now, in some cases, that judgment may well be contested, and then it may go to the Court of Appeal. And then if that's contested again, it may go to the Supreme Court. Now, bear in mind, there's not an automatic right for cases to go up in that way. But essentially, that's the process that can be followed. Now, one part of the Mental Capacity Act is the deprivation of liberty safeguards. Now, I will be producing a session specifically looking at the deprivation of liberty safeguards in more detail. So the deprivation of liberty safeguards came into force in 2009. So those are legal safeguards that apply when an individual is deprived of their liberty in a care setting. Now, essentially, there's two different parts to this. So when the deprivation of liberty safeguards was first created, it was anticipated that the majority of people it would apply to would be residing in hospitals or residential care settings, registered care settings. So that's the main focus. But that said, an application can be made if a person does reside in other settings as well. So this usually applies to those who lack capacity to consent to their care, where people require ongoing support, but where certain restrictions may be put into place to restrict that person's freedom of choice or freedom of movement. So those ensure that individuals are not unlawfully detained and that their rights are respected. Think of it as a process of sort of checks and balances to make sure that a person is protected. Now, a DOLS application for a person in a registered care home or in a hospital would be made directly to the local authority. If a person is in another setting, then an application for DOLS would be made directly to the Court of Protection. But like I say, I want to put together a specific session specifically looking at DOLS and going into it in more detail. Advanced decisions. So advanced decisions are a written statement made by an individual where they have capacity outlining specific healthcare decisions that they want to be made in future if they lose capacity. So when it comes to advanced decisions, you can refuse any medical intervention in advance. So the idea of an advanced decision is essentially a refusal. I'm refusing a particular intervention. Now, you can't refuse heat, you can't refuse shelter, you can't refuse food or water by normal means, whatever normal means for you. But essentially, you can make an advanced decision to refuse any other medical intervention. Now, of course, for that refusal to be valid, you would have to be very clear about the grounds for that refusal. And the situation that transpires in the future would have to align with what you envisaged. Let me give you an example. So say, for example, you said, if I was ever diagnosed with cancer, I refuse chemotherapy because of the side effects. That advanced decision would only be valid if the side effects still remained. So say, for example, there were medical advances, and by the time the time came, the side effects had been reduced. It could therefore be argued that the advanced decision was no longer valid because of the side effects being reduced, primarily because that was your main reason for the refusal. There's also something else called a living will, sometimes called an expression of wishes. And essentially, you can put anything in that you like. And essentially, it's information, it's advice, it's guidance for professionals working with you and family members to ensure that your rights are upheld. What I would say, though, with a living will, or sometimes, which is sometimes called an expression of wishes, it has no legal standing, so it doesn't have to be followed like an advanced decision does. These documents allow individuals to express their preferences and wishes to guide future decision making. Talking about decision making, I thought it would be helpful to talk a little bit about best interests. So in individuals lack the capacity to make their own decisions, the Mental Capacity Act provides a framework for determining their best interests. This process involves a careful evaluation of various factors to ensure that the decision aligns with their well-being and autonomy. Key considerations include the person's past wishes and values, their current circumstances, and a thorough assessment of the potential risks and benefits associated with the different options. The ultimate aim is to arrive at a decision which maximizes the overall welfare of the individual while respecting their individual preferences as much as possible. And I think this is the challenge when it comes to best interest decision making, trying to figure out what is in that person's best interest, not pushing onto that person what I feel is important, and really trying to draw out from that person's past decision making, their past actions, their lifestyle decisions, what specifically is best for them in the present circumstances. As I mentioned earlier on, record keeping is crucially important. Accurate and comprehensive record keeping is crucial in applying the Mental Capacity Act. This involves documenting all decisions made, including the reasoning behind them, the information considered, but also any objections raised. This documentation shows evidence that you have considered all of the information when making a decision in a person's best interests. Now, this is particularly important that not only do I record the decision that was made, I describe how that decision was come to, and maybe if there were particular pieces of information or factors which were particularly pertinent or particularly relevant when I was considering what was best for that individual. Also, if there were any objections raised. Again, it's important that those objections are recorded, again, to sort of show that the approach that we have taken is fair and balanced. I suppose to summarise this particular session, so the Mental Capacity Act is a transformative piece of legislation that safeguards the rights and freedoms of individuals with impaired capacity. So in this particular session, we explored the Act's 5 key principles, the assessment process, talked a bit about the legal frameworks, but also the practical implications for decision making. So the aim of this session was really to provide a solid foundation for professionals and individuals involved with the care or support of individuals with capacity limitations. Also, I suppose, thanks for taking the time to check it out. My plan is that I'm going to be developing more of these particular sessions on a range of different subjects. So if you did find this session helpful, it'd be really, really helpful to me and really would help me to build the channel. If you would like the video, share it with any professionals or any other colleagues who you think may find it beneficial. Please subscribe, because I will be adding more videos as we go through. But also in the comments section, please feel free to comment of any other subjects that you would find to be interesting. So if there's any other subjects you think, oh, that'd be quite helpful, again, just let me know in the comments, and I'll do my best to prepare and to deliver some sessions on those subjects as well. If you would like this session to be delivered for your team or for your organisation, you'd like a bespoke session, then please email me at matt@mattjoyce.com. And I'm more than happy to give you a quotation to put together a session for your particular team. But like I say, thanks for coming along to the session. Yeah, take care, and see you next time.